You're looking at a beaten man. This is Thomas Clare Binger. And he's had a rough 6 months. He got totally annihilated by Kyle Rittenhouse in the recent trial. And so he thought he could turn his attention towards Dominick Black, but he got nowhere there as well. To extricate himself from this position, he is offering Dominick a very sweet deal. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Well, it looks like the Kenosha shooting saga has come to an end. Thomas Clare Binger has offered Dominick Black a deal that Dominick could not pass up, and the judge signed off on it. So it is over. Dominick will not serve any jail time. He'll pay a modest fee, and this won't even go on his record. It is a total victory for the Black family. So let's go ahead and listen in on the proceedings. There's not much here, but there are a few comments that he makes that I thought were of interest.
In the Rittenhouse case, this court ruled that the law 948.60 prohibiting possession of a firearm by a minor did not apply to 17-year-olds. That is a legal issue that could further be appealed and briefed. I personally disagree with the court's ruling, but I respect that ruling.
Oh, I could appeal this, but I'm not going to. And he's right, he could. And he could possibly win. The chances aren't that good, but it's not a given. And this is the reason why it was wise for Dominick to take the deal, because it was not guaranteed that he was going to win under appeal. And it was going to cost him a fortune. Furthermore, he would have to go through a full year of bail, and that has all kinds of stipulations on it. This allows him to walk away from this deal and get on with his life.
And I believe that if this case were to go forward in this court against Mr. Black, that the court would reach a similar legal conclusion with regard to these two charges. So while I do believe that the charges were proper initially, things have changed since then, both in part because of that ruling in the Rittenhouse case, but
Yeah, he's face saving. Okay.
also because of two other factors. Number one, Mr. Black was cooperative in the Rittenhouse investigation. He provided a statement early on, waived his Fifth Amendment right against self-incrimination, and testified at the trial truthfully. And I want to give him credit for those actions, because those are responsible and appropriate actions to accept responsibility and to cooperate.
Yeah, don't believe a word of what he's saying. He was pretty upset at Dominick after that trial. And I went through another video and explained why. There was a golden moment during Dominick's testimony where it was pretty clear that Dominick answered in a way that Thomas Clare Binger was not looking for. And he was visibly upset about it. And you may be wondering, well, how do you know that he's so upset? Why didn't he drop the charges completely? Why is he even talking about filing an appeal?
Second of all, at the Rittenhouse trial, the jury found the defendant, Mr. Rittenhouse, not guilty. In these circumstances, to go forward with these felony charges against Mr. Black, given the court's legal ruling, as well as Mr. Black's cooperation and the jury's decision in the Rittenhouse case, does not seem appropriate.
So in other words, if Kyle Rittenhouse had been found guilty, he'd be pressing on with Dominick Black. So obviously he was upset about Dominick Black's testimony. How much credit is he really giving Dominick when he would have gone ahead and pressed charges against him anyway? Come on.
Mr. Cotton and I had some lengthy discussions with regard to a potential resolution for this case, and it's my opinion that there are no other criminal charges that appropriately reflect the acts of Mr. Black, nor do I believe that any would be appropriate given the factors that I set forth earlier.
In other words, I looked at them statutes really hard to find something I could stick him to, and I couldn't find anything. This is the best I could do was this ticket. It's a county municipal citation. Essentially, when you buy your underage friend a beer, this is the kind of thing you get.
The resolution that we've reached in this case involves the issue of a county ordinance citation for contributing to the delinquency of a child under Kenosha County Ordinance 9-948.40. Mr. Rittenhouse was legally considered a child at the time of the purchase of this firearm, and therefore Mr. Black would be liable for violating that county ordinance. We have agreed to a fine of $2,000 here that Mr. Black will be responsible for paying as a consequence of this citation, and I believe that that does serve as a form of punishment and a deterrence to anyone going forward in the future. Oh yeah, man. It's going to be punishing as hell. That's what they're really scared of, is this $2,000 fine that they're going to get if they buy a rifle for their friend. I kind of doubt it, but that's okay. Look, it's face saving. Let's let him have it. But I want to remind everybody, Dominick Black is pleading no contest. So he's not admitting to the charges. He's basically saying, I'm not going to contest them. I do want to close by saying that I do believe that it is a serious offense to purchase a firearm for someone who is not legally able to do so. Our office will continue to vigorously prosecute those offenders, and it is still our office's position that 17-year-olds should not go armed with firearms. Even though the law seems to suggest otherwise. Okay. Thank you.
Thank you. Mr. Cotton?
I don't have anything else to add. This is our agreement.
Because he totally caved in, I think it's best that I just keep quiet here. There's no need to spike the ball.
All right. On the motion of the district attorney, the criminal charges will be dismissed, and in substitution, well, there's two things about the stipulation that has been presented. One is it calls for an alternative of civil judgment, which is not the procedure here. You could paper the state with civil judgments against people that don't get collected. So I use the old-fashioned remedy, which is assignment to the work crew or sentence to the jail.
If Dominick had been in court today, and he wasn't, but if he had been there, you would have heard him go, jail, jail. They would have had to put smelling salts up his nose to wake him up.
Commitment to the jail. So that would be the alternative, although the clerk just a moment ago advised me the whole bond is on deposit. Is that right?
There is.
The other thing is that the $2,000 I understood was the envisioned outcome. So the forfeiture, it's actually a forfeiture. The defendant's plea is no contest or guilty to the forfeiture?
No contest.
No contest. He's found guilty upon his plea. Forfeiture imposed of $1,500 plus costs and disbursements totaling $2,000 and how much? $2,032 and $50, which is cash deposit forfeited against court obligations. The remainder will be refunded to the person that posted it.
See, actually, this was a big victory for the state. They thought they were only going to get $2,000, but it turns out they're going to get $2,032.50. Woohoo! That makes it all worth it.
Anything else?
No, Your Honor.
Okay, thank you.
Thank you.
Good day.
So there it is, the end. And by the way, I still have a lot of Kenosha stuff that's going to be coming out. I'm not done. Because there's still a lot of the story to be told. Truly amazing. Like my video, subscribe to my channel.